Good afternoon, everyone, and welcome to the Downey Brand 5th weekly webinar on COVID-19. I'm Dale Stern. I'm co-chair of our firm's food and agriculture practice, and I'll be joined today by a couple of my partners who will be speaking on issues within their area of practice and expertise. Before we get started, I want to cover a few quick housekeeping items. First off, just so you all know, this webinar is being recorded. Your voice line is muted, and please leave it that way. You will have an opportunity, though, to use the chat icon at the bottom of your screen to send in any questions or comments you may want to provide. We'll try to address as many of them as we can toward the end of this webinar during the questions and answer session. This webinar and the previous 4 that our firm has put on is available on the Downey Brand website under the COVID-19 Resource Hub at www.downeybrand.com. Feel free to go and see some of the previous webinars. That's it for housekeeping. If you have any comments or questions, please type them in, and our staff here will forward them to us. So at this point, I'd like to hand the microphone over to our partner, Cass Farinini. She's the head of our employment group, and she is obviously very busy right now with questions related to employment issues on COVID-19. Cass?
Hi, good morning, good afternoon, good morning, whatever the case may be. I am busy, as is everybody. It seems like every week there's another round of guidance that comes out in one area or another. So today I'm gonna start with some really interesting protocols that have come out. There was a number of them that came out. First, on April 7th, that was last week, Sacramento County put forth an order that I think is relevant to a lot of folks that are listening, and it applies to all employers that are running operationally right now as essential businesses. Second, there was also new Cal OSHA guidance for grocery stores, which kind of is interesting in that a lot of the things in the Sacramento County order are mirrored in this OSHA guidance for grocery stores. And the thing I think is really neat about this guidance is that while a lot of it is very specific to that industry, some of the things that are suggested in that guidance, I think, are applicable to everybody. So I'll talk about that. And then there was recently, last Wednesday, I guess, LA County issued some rules for grocery stores, which again, I think these rules are interesting for everybody because I think they may be the kind of things that go into place, particularly when everybody ramps back up and gets back into doing business again. So I'm going to start with the Sac County order. It applies to all employers who are essential businesses, and it basically contains a list of social distancing guidelines, and it requires employers to post a social distancing protocol. And that protocol includes certain signage that has to be up and also a notification to your employees. The notification to your employees contains various things, including what you're doing as an employer to protect employee health, what you're doing in your workspace to limit crowds from forming, measures that you are taking to keep people 6 feet apart, measures that you're taking to prevent unnecessary contact, and also sanitation measures. And so if you haven't done so, you should take a look at that order because it does have posting requirements if your business is open. And as I said, many of the requirements are also mirrored in the new OSHA guidance I'm about to talk about, though the new OSHA guidance is specifically for grocery stores and is much more detailed, as you might imagine, because people are handling food and such. So That guidance, which came out Wednesday, and this is from Cal OSHA, has a number of elements, including employee training that has to take place, cleaning and disinfection, physical distancing, hygiene measures, and also protocols for sick employees. So here's some highlights of that. First, employees are supposed to be trained in the symptoms and transmission of COVID-19. Some of the things include telling them how and when to wash their hands. As we all know, hand washing is the new black, I guess. Everybody's into washing their hands. Um, these guidelines from OSHA say that cashiers and baggers should be washing their hands every 30 minutes. Also, before and after eating, before and after prepping food or going to the restroom. Um, the guidance also wants employees to use cloth face covers, and there's also protocols for customers who bring in their own grocery bags, which I'm sure is kind of an ironic and amusing thing for those in the grocery industry, because on the one hand, everybody's bringing in their bags and for a long period of time, and now suddenly bags are not the best thing that you could be bringing into the grocery store. Regardless, there's protocols for that. There's also protocols to train employees in the use of disinfectants. There's certain disinfectants that have been um, approved by OSHA, and those can be found on the Cal OSHA website. The new guidelines also include physical distancing procedures. So, for example, and these are measures that all employers could take, really, a lot of them, staggering lunch breaks and rest breaks so that people are taking them at different times, limiting crew size, uh, using only every other cash register, doing interviews for new hires by phone and video, posting signs at entrances with infection control information for customers, limiting the number of customers that are allowed to enter at any given time, using plexiglass screens, handheld scanners, and then for those folks that are checking themselves out to make sure that there's appropriate distancing. I know a lot of times those folks require assistance in using those self-checkout terminals. I'm one of those people, by the way, that needs that assistance. And so the guidance is that you should be marking on the floor with tape appropriate uh, social distancing. And I know that there's a lot of other of my clients are using this mark the floor with tape thing to make sure that people are aware when they're in the zone of another worker. There was also some guidance regarding what to do with sick workers, which, you know, some of this has been out for a long time, but I still think that there's a little bit of confusion about it. This protocol, as I said, pertains primarily to grocery workers, but again, is widely applicable. So the first thing is have sick workers who are exhibiting the symptoms of COVID stay home. Uh, there's also a guideline that if the fever is above 100.4, they should definitely be staying at home. Also consider not penalizing employees for missing work, suspend no-fault absence policies and things like that. What you don't want to have happen is that an employee is dissuaded from telling you that they might have an issue and they come into work anyway, because then you might have a bigger problem on your hands. They suggest that all employees be trained in self-screening so that they know the symptoms and they can take their own temperature and they can make sure that they're good to go before they show up at your location. They also suggest that employees all use PPE, gloves, eye protection, face covering, and the like. This PPE requirement seems to be something that is in vogue right now, obviously. Um, LA County's order is very heavy on the PPE requirements. LA County in particular is requiring grocery and drug stores to provide gloves, face covering, hand sanitizer, dedicated hand washing stations, um, to all of their employees that are working in that industry, and also to sanitize shopping carts before and after each use. And there's also signage for customers that they want out. So that's probably something that may spread as time goes on. All of that kind of segues into the second question on my list, I think, which is what do you do if there's an exposure in your workplace? Again, send people home and have them stay at home is the guidance that we've been pushing for the last 5 weeks. But there was also some guidance from OSHA on when can employees return. Uh, and employees that are positive should only return after they haven't had a fever for at least 72 hours without using medicine that reduces fevers, obviously. So if they've been taking that Advil for the last 3 days, you want to make sure that they truly don't have a fever for 3 days before you let them come back. In addition, their other symptoms should have improved. Plus, there should be 7 days that have passed since their first symptoms. When you have an exposure, uh, you should identify potentially exposed individuals in your workplace. And there's a lot of ways you can do that. A lot of businesses have cameras, so you can see if somebody's, positive, you can look and see who they've been in contact with. In other workplaces, if my office is right next door to Bob's office, then, Bob and I have the potential for interacting quite a bit. So you should try to identify potentially exposed individuals, have them self-monitor, and that's, again, make sure everybody's aware of what the symptoms are, have people take their temperatures. Some businesses have implemented questionnaires that employees fill out, come into work every day to make sure that they're symptom-free when they arrive at the place, and always consider having employees stay home where that's possible and practicable. There's also OSHA guidance on reporting requirements. And a lot of times I get a lot of questions about, what happens liability wise and reporting wise if we have somebody who's positive in our workplace. So the federal OSHA on Wednesday or last Friday issued new reporting requirements. These require, and this pertains to that Form 300 that you fill out when you have to report, workplace injuries. This guidance does not apply to the healthcare industry, the emergency responders, so police, fire, etc., and it doesn't apply in correctional institutions. So for everybody else who's not one of those folks, OSHA will not enforce reporting requirements unless, number one, there's objective evidence that a COVID-19 case may be work-related. And so you say, okay, well, what is objective evidence? Objective evidence is something like a number of cases among workers who are working closely together and there's no alternative explanation. And I think that no alternative explanation part is interesting, because, if workers in your business are isolated from each other and don't come into contact very often, but go to the grocery store every day, there's an alternative explanation. Whereas obviously if your workers are workers in a grocery store, that is a different scenario. So obviously these rules are very fact specific. The second, so in addition to objective evidence, the evidence has to be reasonably available to the employer. So not just that this situation exists, but that there is some evidence the employer was aware of, a cluster of people that had it or whatever. And those are the circumstances in which you're required to report. So the reason that OSHA did this was they didn't want employers busying themselves trying to figure out the rules when they could be taking other actions to make sure that their workplace is safe. Okay, the other thing is, remember, if you do report it on the Form 300, if the employee doesn't want their name on that form, then don't put it there. Again, all of this kind of relates back to privacy concerns. So my last question relates to hours of work for farm workers, and there's such a variety of impacts on various farms. I know some are going gangbusters right now, and others are laying off employees. So it's a variable circumstance for a lot of them. And one of the issues is, how do I get everything done that I need to get done without enough workers to do it? And so I would just caution that you be mindful of the requirements in Wage Order 14, and remember that those overtime requirements have been changing over time, I think since about 2019. And at this point in time, as of January 1st, 2020, workers can work only 9 hours per day or 50 hours per work week without overtime pay. So keep that in mind as you're trying to schedule these folks and schedule these shifts. Also, keep in mind the requirement of 1 day of rest in 7. That same legislation that started the gradual reduction of hours, straight time hours, also had the effect of making the labor code, certain labor code provisions applicable to ag workers when they weren't previously applicable to ag workers. So you have to have that 1 day of rest in 7 unless the work is being performed to protect life or property from loss or destruction, or if the nature of the employment reasonably requires work of 7 or more consecutive days, you're allowed to require that as long as each month the employee receives the equivalent of 1 day off in 7. And then always, whenever you using an exception or varying from any labor code provision, it's always smart to document the circumstances and conditions that led to the position that you're in where you're using those exceptions. Also, kind of on that same topic, there was an interesting note on Wednesday. The Department of Homeland Security announced that they'll be issuing new rules allowing migrants with H-2A visas to switch employers without approval, and also to allow visa holders to stay in the U.S. For longer than 3 years. I don't think those are out, and of course they may change, but with the current recent environment prior to COVID-19, where there was quite a great deal of enforcement of immigration laws, there seems to now be an appreciation for the fact that the food supply chain is pretty critical. And so I will leave you on that note, and I'll turn it over to Becky.
Good afternoon. Thank you all for joining us. I'm Rebecca Smith. I'm a partner in our public agency and water practice. And I know many of you on the phone, and I very much appreciate you calling in. One quick reminder before I get into my slides. We do have a chat box available for you all in our kind of web app here. We will address some questions at the end. I know that we're covering a broad spectrum of material here, and we want to make sure that anything that's on your mind, we're able to capture it. So if something comes up during the course of this, we will be, again, addressing those questions at the end, but feel free to send us a little chat message, and we'll circle back with you so that we can be helpful. A reminder to all these materials, both this week's webinar as well as historic webinars are available on our website. Some of these will be revisited topics, and a lot will be kind of freshen up to the minute. So with that, I'm here to talk to you about the both the statewide shelter-in-place order as well as many of your county-specific orders, and how you as business owners are going to navigate those constantly changing directives. This is particularly salient, I think, given that although the statewide order has been in place for about a month, county orders continue to change. And as you all know, yesterday we got news from the federal administration, some guidance about how we expect the economies and these businesses to reopen up as we move out of shelter in place. And the Newsom administration earlier this week as well has indicated that hopefully within the next 2 weeks we'll be providing additional guidance about what the step back to a move away from shelter in place will look like. So a reminder, we had our statewide shelter in place order at the end of March. That order says generally, Californians, please stay home unless you work in an essential business. Most of you on the phone here are in some form of essential business, but of course the answer is not quite as simple as all of that. So the statewide order refers to a document prepared by Homeland Security that outlines several areas of critical infrastructure. And one of those areas is agriculture, and there are in fact some specific examples in food processing, in farms and cultivation, in veterinary practice and services, drug development and delivery, among others. All of those are included within essential work, but the shelter-in-place order does not stop there. So those of you who are in essential businesses also are looking at, in California, are also looking at your county-wide orders. The vast majority of California counties have now adopted their own county-specific orders. Those orders are not necessarily consistent with the state order. In most cases, and I'm gonna generalize fairly broadly here, but in most cases, those orders incorporate in some way the state order and also the federal guidance on what is an essential business. For those of you who have not yet seen that guidance, it's a late March memo from the Department of Homeland Security. It's also linked on our website as a real easy access, as well as within the state's COVID response website. So a good resource for you. But you, as individual business owners, really ought to be thinking about what's happening specific in my county. If you are operating in Fresno County, for example, the rules are going to be slightly different than Sacramento County. So we want to be aware of what those rules and restrictions are. These, again, mostly incorporate the state order, but may also, for example, in many counties require face coverings for employees, may require the posting of a social distancing protocol. That's true in Sacramento County as well as a number of others, that employers need to be posting their social distancing protocols. And then they may also, and this is important for many of you who have a mixed-use business, may direct that you slow or stop your non-essential functions within your business and keep the essential functions going. That's obviously a very difficult determination to make, and I want to remind folks here, when we look at the shelter-in-place order and we look at these directives to social distancing, there are some priorities here. We are being asked to shelter in place, but it's very clear under the state order and under most of your county orders that to the extent your workforce can do work from home or work remotely, they are certainly welcome to do so. And so many of you are going to be making some accommodations in order to facilitate that work. You are also going to be entitled, even for those of you who are in what we'd consider a non-essential business, to do the minimum necessary to keep your operations going. There's exceptions in most of the statewide order, or in the statewide order as well as most of the county orders, that would enable you to do kind of minimum necessary operations. This is not meant to be a loophole to prevent people from complying with the stay-home order, and I'd encourage you, if you are in what might be considered a non-essential field, to be carefully documenting that. One question that we've seen recently from a number of clients is, What's the level of enforcement we're seeing out here within these orders? Each state and each county health department has almost all of these orders have said, we hereby delegate to the county sheriff the ability to go out and issue citations related to noncompliance with these orders. For those of you who are on the phone and have seen that happening in your local jurisdiction, let us know by chat, because we'd be very interested to see where it's actually playing out. When the orders additionally came out, we saw quite a bit of activity by sheriffs that has now slowed down, although we are hearing in a number of different jurisdictions that folks are issuing tickets for those failing to comply with social distancing in public. We have not seen a whole lot of enforcement against those designated as essential businesses. Any disputes about that, although there's a potential that may continue into the future. And that takes us to where we go from today. So as you know, we've got some federal guidance out that suggests a path forward for reopening. But that path, for those who have looked at it, is very much focused on a gradual reopening, as is Governor Newsom's outline that he laid out. And so that means that for those of you who are working through shelter in place, we need to start having a system in place that you can expect to see in the longer term and a slowly phased reopening. I'd encourage, and I will welcome my fellow ag lawyer and my employment lawyer to jump in here as well. I'd encourage you to be documenting how you are complying with essential business regulations and keeping a close watch on your county orders. Across the board, all these county orders all expire. We've already seen extensions of a number. They all expire at the end of April or the first week of May, and that's going to coincide with the statewide, the anticipated statewide announcements regarding what it will take for California to reopen. So you can expect counties to be responding to that here, and you really need to be watching your local jurisdictions and in particular your local public health offices in order to make sure that we've got the appropriate regulations and rules in place. So, and with that, I'm going to turn it over to my wonderful colleague, Dale Stern, who many of you know. So take it away, Dale.
Thank you, Becky. I've never been called wonderful before. That's fantastic. Thank you. So we've covered employment issues and state and county policy issues. I'm going to dig a little deeper into the weeds with the questions that I was asked to talk about today. The first one is related primarily to food packaging, processing, manufacturing. Second one is deals with pretty much every aspect of the food production business. And then the third one deals with both sellers of agricultural commodities and buyers of agricultural commodities. So first, with respect to food manufacturing, food processing, you heard Cass earlier talk about the OSHA requirements. And when you have an employee who either reports that they have tested positive or who you send home as a result of showing symptoms in the workplace. A question has come up from a number of food processing companies as to whether you also have an obligation to report those facts to the California Department of Public Health, specifically to the Food Safety Branch that will, and that branch is responsible for inspecting and auditing food manufacturing facilities to confirm that you're complying with food safety requirements, both state and federal. In many cases, the state food safety branch carries around the authority of the FDA with them at the same time. A few of our clients have heard from Department of Public Health Food Safety Branch that it is a mandate, it's an absolute obligation that if you have an employee who is or may be infected with COVID-19, to report that fact to the Food Safety Branch at the Department of Public Health. We didn't think that was consistent with what the statutes require, so we pursued that issue, and in the course of talking with people higher up in the Food Safety Branch, we confirmed that that's not a requirement. And so what the rule is that under the general Department of Public Health, a physician who has a positive COVID-19 case has an absolute obligation to report. Anyone other than a physician, a treating physician who is aware of a positive COVID-19 case may report it. It's not an absolute requirement. And further, if you aren't confirmed that one of your employees has COVID-19, but you've sent them home because of symptoms, or a family member may be positive, or some other indicators that have caused you to take steps under your protocol, but it's not a confirmed COVID-19 case, you do not have an obligation to report that to the food safety branch. Now, obligation and whether you should are perhaps two different issues. I'm sure you've all seen the press about the Smithfield food manufacturing facility in South Dakota and a few other plants around the country where there have been employees that have come up positive, and allegedly the company is not taking adequate action after learning of that fact, and they end up with a hotspot with a number of employees that are testing positive. So even though it's permissive to report to the food safety branch at the Department of Public Health, consider whether you, just for purposes of being a good citizen, or for purposes of creating a record, or for purposes of avoiding potential adverse press down the road, like some of these plants have experienced, should you report a positive COVID-19 case to the Department of Public Health. That's something that you and your management team need to carefully consider. It's going to be fact-specific depending on your particular circumstances. You know, as Cass mentioned earlier, some facilities have cameras everywhere, and if you can identify that the employee who tested positive worked alone, or you can isolate 2 or 3 other people that person worked with and deal with it under your protocols, you may decide not to report to the Department of Public Health Food Safety Branch. But if they were on a heavily populated assembly line in close proximity to a number of other people, just from the standpoint of avoiding potential future adverse publicity, you may want to go ahead and report that and invite whatever assistance the department is willing to offer to you. So I wanted to clear that up for anybody who had heard from public health that it's an absolute mandate, that in fact it isn't, but you should still consider whether or not to report. The next question that I was asked to deal with has to do with FDA's reported relaxation of food safety, food labeling regulations. So the FDA has announced just recently that they're aware of the concerns in some parts of the country that the food supply system is not getting into getting out to the public as rapidly or as efficiently as it should. Even though there's no shortage of food, we're all being told, there are some concerns about the distribution system being able to keep up with the panic buying and the overall shift in food production from, in most cases, large percentages of food production go towards food service, restaurant, cafeterias, and other large operations. And food manufacturing is now pivoting and focusing more on consumer-sized packaging and consumer-labeled packaging. And so the question is, are food manufacturers, food processors, food producers, and even retailers required to have all of the same food nutrition labeling compliance with all of your packaging? And the FDA's recent release says that in order to facilitate the distribution of food during the COVID-19 pandemic, they're going to relax some of their requirements. So if you have food already packaged for food service and it's not fully labeled, you know, with the full nutrition panel and so on the back, the FDA will allow you to go ahead and sell that direct through retail to consumers, even though it's not fully and properly labeled. And there are some requirements, though, for that food label, for the label on that food product, that even though they're relaxing the requirements, it still must contain the usual things that you all would naturally include: a statement of the identity of the food, a statement of its ingredients, the name and place of the business of the food manufacturer, packer, or distributor, the net quantity of the contents, and if there's any allergens, you have to include that disclosure. So if you have food that's already packaged for food service and it includes those required items, you can go ahead and sell it through retail to the consumers, and it will not be considered a violation by the FDA at this time. Now, if the packaging does include a nutrition or health-related claim, good source of protein or high in vitamin C or something along those lines, then you are required to have the full food nutrition panel like you would on any other retail packaging. Now, most food service type packaging doesn't include those kinds of claims, but if you happen to have one that does, then you need to have the full compliant nutrition panel label on your packaging. There's also some relaxation of the enforcement by FDA if retail packaging just isn't available. You didn't have enough in inventory as you pivot your packaging from large bulk quantities into consumer-sized packaging, and you just don't have enough packaging available. You are able to go ahead and package in a fashion, however you can come up with, in a safe and secure fashion, as long as it includes those same things I mentioned a minute ago: statement of identity, ingredient statement, name and place of your business, the net contents, and any allergen disclosures. You can basically come up with whatever packaging process you can in order to get the food out to the consumers. The FDA regulations also included relaxation of some of the rules on shell egg labeling. I won't go into that in any detail now. I don't see any egg companies on our list of attendees, but we can certainly answer those questions if you have any about the FDA's new egg labeling regulations. One thing that's not on my list that I wanted to touch on just quickly, at last week's webinar, our partner Steve Hymas in our corporate group talked about eligibility for the Paycheck Protection Program and the EIDL loans, both administered through the Small Business Administration. And the question that he was answering was whether production agriculture, whether farmers are eligible for both. And I believe he confirmed that the PPP, the Paycheck Protection Program loans, are available to production agriculture. But the EIDL loans, it was unsure whether those are covered and available to production agriculture. When Congress put the bill through that provided these benefits, these programs, most congressmen will tell you that it was intended by them to cover production agriculture and their eligibility for EIDL loans, but the Small Business Administration is saying, no, that's not their understanding. So last week, Steve was unclear as to whether that had changed any, and as of today, it still has not changed. SBA is telling us that EIDL loans are not available to farming, but the PPP loans still are, to the extent there's any funds available. So I wanted to go back in time and touch on that real briefly. The next question I was asked to talk about are in contracts for the sale or purchase of agricultural commodities. An issue has come up time and time again in the last month as to whether the force majeure or act of God paragraphs create an excuse from performance of your obligations under an existing contract. And the answer is fairly legalistic and fairly detailed. I'm going to try to just give you a high-level overview of it for the purposes of this webinar today. The shorter answer is it depends. The force majeure or act of God paragraphs are in most cases worded quite differently. In some cases, you see a long laundry list of all of the events that might become an intervening event and create a force majeure or constitute an act of God that would excuse your performance. Other paragraphs we see in contracts are very straightforward, just something real simple like an intervening event that interferes with our ability to perform that's outside of our control. And so how each of those variations and everything in between applies to your situation is going to be very fact-driven. Across the country, every state deals with these kinds of paragraphs a little bit differently. In the case of California, it's a little less stringent. In other words, they're a little more forgiving and flexible in interpreting those paragraphs in contracts and how they apply. So in many cases, There is no paragraph in contracts that is a force majeure or acts of God paragraph. California has a civil code section 1511 subpart 2 that provides for a basic force majeure or act of God protection if an event interferes with your ability to perform. Now, all of this comes up in the context of whether this pandemic is, in fact, the type of event, intervening event, that would give you an excuse not to perform on your part of a contract. There is no reported court decisions in California on whether any sort of a mass illness or pandemic or other event of that type would constitute a force majeure event. So we're kind of shooting in the dark a little bit here. Clearly, if your force majeure paragraph in your contract uses words like pandemic or large-scale illness or something along those lines, you have a much better shot at the paragraph being applicable. But again, most of those paragraphs in contracts, force majeure paragraphs, do not include that specific of language. So it really comes down to, under the court rulings in California, the precedent that we have here as to whether your ability to perform is impossible. And the focus is on the impossibility of the nature of your performance, not on your inability to perform. So let me give you some examples. We're hearing from a lot of grape growers that wineries are citing the pandemic and the slowdown in sales of wine at restaurants and other on-site consumption facilities, bars and whatnot, and therefore the wineries don't have the money to pay the growers for their grapes. Obviously, that's not been decided by a court, but our interpretation of most of those paragraphs would be that the mere inability to perform does not constitute an act of God that would excuse the winery from paying the grower. Likewise, vendors who sell to retail grocery, farmers who grow any kind of crop for fresh sales or processing, the inability to pay because of the pandemic, my prediction, don't know this yet because the courts haven't ruled on it, but my prediction is that the inability to pay because the economy has taken a turn for the worse will not constitute an act of God that excuses you from performance. If you're attempting to assert a force majeure provision and excuse from your performance, the burden's on the party making that assertion. And the standard of proof is fairly high. The courts have used a number of different phrases, but they all come down to what I just mentioned a minute ago, the impossibility of the nature of the performance. In some cases, the courts have said an irresistible superhuman cause or act that is outside of your control. Others have used the words insufferable interference as could not have been prevented in the exercise of due diligence. And others use words like impossibility or frustration of purpose. All of those would have to be applied to the specific product you're selling or buying, to the specific reason why you're unable to perform your part of it. So for example, if you just cannot get a labor force because there aren't workers available, and you have a contract that obliges you to deliver a crop to a distributor or to a processor, and you can't get the workforce to get the crop out of the field, that in most cases is probably going to be interpreted as a sufficient intervening event under a force majeure paragraph in a contract. And probably even if you don't have a force majeure paragraph under that Civil Code section 1511, that's probably a legitimate excuse. So simple things like my building burned down or I can't get a workforce, those kinds of things are pretty straightforward. But the real difficult ones are where there's a less obvious, less direct interference with your ability to perform. So our recommendation is that you consider all of your contracts, whether the paragraphs, if you have one, whether they are worded in a way that would sufficiently cover all things you think might happen. And then as issues arise, consider them on a case-by-case basis and don't hesitate to call with any questions. The last topic they wanted me to cover is just any other topics that we're hearing pop up around the agricultural, food processing, and retail industries. Becky mentioned earlier that we're seeing some differences in the definitions of essential businesses on a county-by-county basis in their various orders. We have run into a few where there are significant differences between the CDC recommendation, the state order, and the county order that are creating some uncertainty and potential concerns for people involved in not necessarily directly in the production of food or the processing of food, but ancillary businesses. For example, manufacturing of packaging, distribution of packaging, those kinds of things have come up as potential problem points. In some of the counties where those more rigid ordinances or orders have been issued, we recommended that operators in those counties send a letter to the county health department explaining, this is what my company is, this is what we do, and here's what we are producing or distributing or making or growing or whatever. We believe we are fit within the definition of an essential business for the following reasons, and if you disagree, please let us know right away. And we're finding that everyone who's done that I've talked to has received back either confirmation that they're correct or no response back at all. So if you're concerned at all about whether you fit within your county's definition of an essential business, it's probably worth reaching out and trying on the affirmative to validate what you're doing.
If I might add one point to that too, Dale, this is particularly useful advice because most counties, in fact, all counties, really have not made a practice of affirmatively going out to their essential businesses and hitting them with a rubber stamp and telling them that, yes, you are an essential business. So if there is a point of question, this is a little bit of a CYA move that allows you to kind of do at least your kind of minimum due diligence to establish where you think you stand.
Yeah, thank you, Becky. And as you mentioned earlier, I think maybe before we started the call, employers that have a concern about their workforce getting to work, maybe being intercepted along the way and questioned as to why they're out and about in some counties, preparing a letter on your company letterhead that explains what business your employees are involved in and why they are essential and why your business is essential will help those employees get through roadblocks, particularly where the employees may not be English as a first language speakers. At that point, I've exhausted my prepared comments. We're looking at the potential questions that are coming in. If there are any, feel free to send them using the chat icon at the bottom of your screen. While you're typing in your questions, I will remind you that next week our webinar will take place on Friday as usual. It will be our 6th webinar. I'm not sure how many more we're going to do, but for the time being, we're still on a weekly basis. And you can access all the past webinars on our website through our COVID resource hub. Today's program will be available probably this coming Monday. All right, we're not seeing any questions. We'll interpret that as though we've covered all your bases and we've answered all your questions. Just to confirm, we put these webinars on every week as a way of providing general information and recommendations. To the extent that you need specific legal advice on a particular issue, speak with us or your attorney and get advice that's factually and legally specific to your situation. And consider these webinars to be general information.
And, before we close, one final note, we know that we're all kind of in this shoulder to shoulder and together, and we appreciate you spending your Friday afternoon with us. We've had questions in the past about whether these are just limited to clients or can we share these. Please, we want to bring this community together, and we welcome you sharing these webinars. We welcome you revisiting them. They're still archived on our website, and you're certainly you're welcome to go back and check them out, and you're welcome to reach out to any of the presenters and follow up with them. We want to be a good resource for you, and we're looking forward to celebrating our successful recovery from all of this together. So,
absolutely. Thank you. Thank you, everyone.
Yep. Thank you much.
Thank you.